Okay, it's 1 o'clock, so let's begin our webinar. Welcome to today's webinar called ERISA Litigation, Year in Review and Trends to Watch. My name is Brian Lamb. I'm the practice group leader for Thompson Hine's Business Litigation Group and a partner in our Cleveland office. I'm joined today by Nate Ingraham, an associate who resides in our Washington, D.C. office. And as you were about to learn, he's the brains of this operation. And our goal here today is to bring you up to speed on some developments going on in the wonderful world of ERISA litigation. There's lots of evolution going on here. We're gonna, if there's a theme that ties our presentation together today, it's that the plaintiff's lawyers follow the money. And there is a lot of money in various kinds of ERISA plans, and so the litigation follows. Before we begin, a few housekeeping items. Our program is being recorded, and within 48 hours after the presentation, you'll get an email with a link to the slides and a recording if you care to listen to it again. And if you have any questions during the webinar, feel free to use the question box located in the control panel on the right side of your screen. We will answer all the easy ones. We don't promise to take any of the hard ones. We do appreciate your interest, and with that, we're gonna turn to the contents of our presentation. Nate's gonna talk about developments in 401k plan litigation, including excessive fee litigation and target date fund litigation. And then I'll talk about health plan litigation and some defined benefit plan litigation. So if you're not that interested in the particular topic at the moment, don't worry, we'll be turning to a new one shortly thereafter, and we will finish in 1 hour promptly. Thank you for your interest, and with that, I will turn it over to Nate.
Hi everyone, this is Nate Ingraham, and it's a pleasure to be here and to speak today on the topic of ERISA litigation. So the first subtopic, I'm going to provide an update on excessive fee litigation in 401k and 403b plans. I think this is a good first topic to cover because fee litigation continues to be something of a headliner in ERISA litigation. 2023 was a very active year. Courts remain very busy handling all the cases that have been filed, and we've seen some new trends in this past year. So I want to start with some brief background. Fee cases or excessive fee cases are class action lawsuits brought by participants of 401k or 403b plans challenging the fees or investment options of their plan. And the core theory of these cases is that the plan fiduciaries breached their duties of prudence or loyalty because they allowed excessive fees to be paid, or there were issues with the investments offered in the plan. Although we use the term excessive fee as a catch-all in these cases, it's not the best descriptive term because there are actually some cases that don't focus on fees. There's some cases, including some we'll talk about, that are really focused on plan investment performance specifically. I think you may be familiar with some of the recurring allegations that we see in this space. So a lot of lawsuits focus on plan-wide expenses and issues with plan service providers. Plaintiffs frequently take aim at the record-keeping fees in plans. They'll claim in suits that the plan neglected to do an RFP or didn't do a timely request for proposal. Plaintiffs also frequently challenge record-keeping arrangements and how fees are paid. And then a lot of suits as well focus on the plan investments that the fiduciaries select and then monitor. One of the most frequent recurring claims in these lawsuits is the failure to be in the lowest cost share class of a mutual fund. Many cases focus in particular on performance of investments. And then from time to time, cases are filed targeting financial services companies that offer affiliated funds in their plans. So I want to step back just for a minute and go over some trends in this litigation. Fee litigation, it dates all the way back to the mid-2000s, but we've really seen this litigation explode in recent years. So as this slide illustrates, around 300 class action lawsuits have been filed since 2020. And that is a really big increase over historical time periods. The all-time record was in 2020, where there were over 100 cases filed. 2022 was another super busy year with 89 cases. In 2023, we did see a noticeable slowdown relative to the prior few years. I'll say to that cases are actually still up relative to where they were historically since the inception of the fee litigation almost 20 years ago. So these cases are still being filed at a rapid clip, but it has been slower over the past couple years. And I think my view is that the likeliest factor for the slowdown is there's a need for the plaintiffs' law firms to manage the existing caseload, which are working their way through the courts. There are really only a certain number of plaintiffs' firms that really specialize in bringing these cases. That number is actually growing because more plaintiffs' firms are getting into the ERISA space. But some of the most well-known plaintiffs' firms went to trial this past year, and were otherwise busy handling cases they filed in 2022, which were heavy filing years. So looking forward to 2024, we'll have to see if the slower pace continues or if we'll start to see more of an uptick. So looking at 2023 specifically, there are a few trends that stand out. The first trend is really not surprising, and it's something Brian alluded to in the introduction, and that is the plaintiffs' attorneys are continuing to follow the money in these cases. So it's still the case that most new lawsuits are being filed against the biggest defined contribution plans, plans with $1 billion or more in assets. It is true that fee litigation has moved downstream to a certain extent to target more medium-sized and smaller plans. And so in 2023, for example, there were lawsuits targeting plans with $100 million in assets and $140 million in assets. And in the past, even smaller plans than that have been targeted, but that really is not the norm. A second trend that we saw in 2023 is that the number of plaintiffs' firms getting involved in this type of litigation has continued to expand. So we've seen some firms enter the space that had previously been focused on bringing employment lawsuits, and they've branched out and started filing ERISA lawsuits. There's been other firms that have been ERISA litigators, but they've handled different types of ERISA litigation, and they've gotten into the space. And I've even seen some personal injury firms appearing on cases. And so for sure, this continues to be a hot and growing area of litigation. A third trend this past year is that the plaintiffs continue to develop new case theories we hadn't seen in the past. An example of that was a really newsworthy suit brought against American Airlines, filed by a pilot. And he alleged in a class action complaint that the 401k plan included funds that improperly promoted ESG related factors. And the topic of ESG, we don't have time to cover that today. That could definitely be the topic of a different webinar, but I wanted to put this up there just to illustrate a new type of lawsuit that's being advanced. Another novel theory that we saw this year was in a series of lawsuits challenging the allocation of forfeitures in 401k plans, and we'll touch on those a bit later in this presentation. I want to spend a few moments talking about the state of the pleading standard in 401k cases. And what I mean by that is, what does it take to advance one of these cases past the motion to dismiss stage of a case, at the initial stage of a case? And in recent years, there has been a lot of focus on the appropriate pleading standard. And I think for good reason. I think, courts have really struggled with this issue, but I think it's a good place to put emphasis, because when one of these class action lawsuits is filed, the prospect of dealing with one of these suits, can be somewhat intimidating. But with a motion to dismiss, you can potentially get the case dismissed, at a much earlier stage, sometimes, but not always, before discovery has begun in the case. And once one of these cases passes the motion to dismiss stage and discovery begins, stakes get much higher, litigation costs can really increase, and there may actually be monetary incentive for companies to consider exploring a settlement. And it is true that most of these cases do settle before trial. As of 2022, there's been over $1 billion in settlements. So the Supreme Court had an opportunity to look at the pleading standard in the high-profile case Hughes v. Northwestern back in 2020. And as you may be familiar with that case, the Supreme Court issued a very short, narrow opinion and essentially punted that case back to the appellate court. And that's what we've seen happening in the wake of Hughes, is that case law has been steadily developing in the circuit courts of appeals. Some of this case law has been favorable to plan sponsors, and some of it has been more plaintiff friendly. But I think the big takeaway here is that the pleading standard is uncertain, going into this year. 2023 was interesting in that there were multiple excessive fee cases taken to trial. Trials in this area really aren't common, but we saw a few trials in 2023. And in fact, there were a couple big victories for plan sponsors. And in particular, there were big wins, big defense victories in cases against Yale University and B. Braun Medical. The Yale case was a long simmering case brought way back in 2016, targeting Yale's 403B plans. And that case was tried before a jury in the District of Connecticut last year. And jury trials in this area are quite unusual. So that was noteworthy in itself. The B. Braun case was brought more recently in 2020. And that case was tried before a district judge in the Eastern District of Pennsylvania. Both of these cases have some similarities in that they're really focused on administrative fees, but there's also some differences given the different types of plans involved. But a real commonality in these cases is that the defendants were able to gather a lot of facts during discovery, demonstrating the plan expenses, demonstrating that the plan expenses and investments were carefully monitored. And that certainly proved to be a winning strategy in both cases. I'll just note that the Yale case is currently on appeal, so it's not totally final, but the B. Braun decision is final because it was not appealed by the plaintiffs. These trials are definitely big wins. I think it goes without saying that taking a case to trial is not cheap. It comes at a cost to an extent, but I think big wins like this, can potentially have a deterrent effect on case filings. I would say the main takeaway for this discussion on fee litigation is that it's not going away anytime soon. It's definitely here to stay for the time being, at least. And so, fiduciaries, should continue to focus on documenting their process with respect to plan expenses and investments, meeting regularly, keeping minutes, monitoring their service providers, and going through, regular fiduciary training, including, keeping abreast of some of these fee litigation cases. All right, so now I want to switch gears and talk about a few particular theories that that are being asserted in 401k fiduciary litigation. And in particular, I'm going to discuss the state of target date fund litigation, and then also touch on some recent litigation challenging the allocation of forfeitures in 401k plans. So starting with target date fund litigation, this has been an extremely active area over the past several years. TDFs, or target date funds, they're funds that automatically adjust their profile, their risk return profile, as a participant approaches their retirement date. And there, as you can see, there's a ton of assets invested in target date funds. They're often the QDIA, the qualified default investment alternative in a plan, which leads them to be, a widely held option in retirement plans. And that is, as we've said multiple times, that makes them an attractive target for litigation, and it can also drive up the potential damages in one of these target date fund suits. So there's been a lot of focus on these, and the typical theories in a suit challenging target date funds is either underperformance or cost, or often both. So looking back since 2019, the trend here has been plaintiffs have filed these lawsuits in waves. They've taken, I'd say, a volume-driven approach. They'll look at a particular target date fund that's offered, that's widely offered across defined contribution plans, and then file a series of lawsuits targeting that fund, across the country. Many different TDF series have been targeted, including the Fidelity Freedom Funds, more recently the BlackRock LifePath Index Funds, and many, many others. And I want to spend a few minutes discussing the Freedom Fund litigation, because I think that provides the backdrop on where we are today, or at least some of the backdrop. So these Freedom Fund cases challenge the Fidelity Freedom Funds, which use active management strategies. And the plaintiffs, starting in 2020, plaintiffs' firm filed a series of complaints challenging these funds, and they compared them in particular to another Fidelity target date fund series, the Fidelity Freedom Index Funds, and the index funds use passive management strategies. And essentially the complaints alleged that the index funds performed better than the Freedom Funds, and were less risky, and were cheaper as well. So the initial wave of these lawsuits was filed in 2020 by a single law firm called Miller Shaw. And then after that wave, there were actually a bunch more cases filed in 2021, 2022, and other plaintiffs' firms started filing these complaints as well. So these Freedom Fund cases have been going on now for several years. A lot of them have wrapped up at this point. And we've seen, looking at some of the outcomes in these cases, plan sponsors have had a couple big victories, notably in the Common Spirit case, which was in the Sixth Circuit. That case, the Sixth Circuit dismissed one of these Freedom Fund complaints with prejudice, and it was upheld on appeal. But a lot of these cases have actually proceeded to discovery. And as this slide shows, there's been a variety of settlements varying in around $1 million to over $10 million, depending on the size of the plan involved. So there have been quite a few settlements here. So skipping forward from 2020 to 2022, so the same law firm that initiated the Freedom Fund litigation, they filed another series of lawsuits challenging the BlackRock LifePath Index Funds. So I think because the same law firm's involved, I think of the BlackRock litigation as a sequel to the Freedom Fund litigation. And these complaints, taking aim at these BlackRock target date funds, they claim that these funds didn't perform as well as other leading target date funds offered by Vanguard and T. Rowe Price and some others. The BlackRock cases only focused on, they're one of those cases that only focused on performance. And that makes them different from the Freedom Fund cases, which focused on both cost and performance. In fact, in these BlackRock complaints, these are target date funds that use passive management strategies, and plaintiffs admit that these funds are very low cost. So when these cases were filed, they generated quite a bit of concern across the industry. And the concern with these cases was that if companies can be sued for offering these types of low cost funds, then really no plan sponsor is immune from facing one of these lawsuits. So let's take a brief look and see how these cases have shaken out. And this chart shows here that really these BlackRock cases have not gone well for the plaintiffs. So out of 12 lawsuits filed in 2022, at this point, 10 have been dismissed, at least preliminarily. In some of the cases, the dismissal has been with leave to amend, so there'll be a subsequent decision on the plaintiff's amended complaint. But 10 have been dismissed, at least preliminarily. One case, we're still waiting on the court's ruling on the motion to dismiss. And then there was one case against Genworth Financial in the Eastern District of Virginia that is in discovery because it was allowed to proceed past the motion to dismiss. And the courts that have dismissed the BlackRock cases have really honed in on two different rationales for dismissal. And these are, you can find these in other excessive fee lawsuits as well, not just target date fund suits. But one of the factors here focuses on the comparisons made in the complaints, and then the other factor the court considered is a performance factor. So starting with the comparisons point, so many courts have held that the plaintiffs have to provide a valid comparison, or as sometimes we say, an apples to apples comparison to a fund that they're challenging to get past a motion to dismiss. It's really not enough, courts have held, to just say that an investment is bad and compare it to something that is totally different. And the BlackRock dismissals in these court orders, they pointed out that the BlackRock funds aren't really comparable to the other target date fund series, like the Vanguard funds and T. Rowe Price funds listed in the complaint. The defendants argued, and the courts took notice of, that the funds have different strategies. They have different allocation of investments, and in some of the comparisons, there's comparisons being made between active and passively managed funds, which many courts have held is not a valid comparison. And then going to the second reason that focuses on performance, a lot of courts have held that it's not enough to say one fund has underperformed another fund over a short period of time to get past the motion to dismiss. There really has to be more. And what the BlackRock complaints argue is that there was, underperformance by the BlackRock target date funds relative to these other funds over 3-year and 5-year time frames. And courts have found that that this is really not enough to infer an imprudent process, which these cases, which the ERISA's duty of prudence focuses on, this process. So I mentioned before that there was one BlackRock case that was allowed to proceed to discovery in Virginia. I'll just note that case is unique in that that the court moves really fast in Virginia, in the Rocket Docket, as it's known, and the court allowed some early discovery to be exchanged while the motion was pending. The motion to dismiss was pending, and so the plaintiffs included more factual detail in their complaint in that case than they did in other cases, and so it's distinguishable, I'd say, for that reason. I think the major takeaway here for these BlackRock cases is that, well, first, no cases have been filed since 2022. And I think that reflects that this particular theory advanced by plaintiffs has not been successful. I think these cases, push the envelope in challenging this low-cost target date fund. And I'll just conclude this section by, it's similar to what I said about other excessive fee litigation, is that target date fund litigation is going to continue given how prevalent target date funds are in plans. And so there's been pushback on this recent theory involving the BlackRock LifePath Index funds, but plaintiffs are going to keep coming up with new theories. So it's definitely important to keep a focus on your target date fund if your plan includes one, and proactively review them over time. So the last topic I want to cover in the 401k area before handing things off to Brian is a trend that emerged late last year. And so a wave of lawsuits were filed challenging what 401k plans use their forfeiture funds for. Forfeitures happen when a plan participant terminates employment without being fully vested in their account funds. And the non-vested portion of the funds are forfeitures, and they go back to the plan. So late last year, 5 lawsuits were filed by one plaintiff's firm targeting very large companies. And as this slide illustrates, these cases were all filed in California. The plaintiff's firm that filed these suits is also based in California, which explains that. And the lawsuits claim that the sponsors of these plans were supposed to treat their forfeitures a certain way. And in particular, the plaintiffs are claiming these suits that they're supposed to use the forfeitures to offset plan expenses, as opposed to using them for employer contributions. And basically, the complaints say that the plans here were harmed because the sponsors could have used the funds, the forfeiture funds, to pay plan expenses, but instead used them to reduce employer contributions. And the overarching theory that the plaintiffs are advancing here is that this benefited the plan sponsor at the expense of the plan. And plaintiffs are alleging that this was a breach of fiduciary duty, and there's also prohibited transaction claims as well. So these cases are in their infancy, and we haven't seen any court decisions, but I would think we would see some case law being developed, within the next several months. Motions to dismiss in these cases are currently being briefed. I believe one of the cases has already been scheduled for an oral argument on the motion to dismiss later in February. And so we just wanted to point out a few of our observations of these complaints, and in particular, a few weaknesses that we see in these complaints that courts might recognize. And just to go over a few of these, this is not an exhaustive list, but definitely a headlining list. And so the first weakness that we see here is that the practice of using forfeitures to reduce employer contributions, and this is essentially what the plaintiffs are complaining about, that is permitted under IRS guidance. So the IRS has issued guidance on how employers can handle forfeitures. And the IRS has said that employers can use them to pay plan expenses, reduce employer contributions, or they can reallocate them to the remaining plan participants. And so the theory of these recent forfeiture complaints is at odds with what the IRS has said on this issue. And the theory of these complaints is also at odds with the plan documents of the plans being challenged. The plaintiffs actually admit in these complaints that the plans provided options to the employer on how to treat the forfeitures. So the plans permitted the employer, and this is very common, to use the forfeitures to pay plan expenses or to reduce employer contributions. So what the sponsors are doing here is consistent with the plan document. And then a third issue with these complaints is it's very debatable whether this type of claim can really support a breach of fiduciary duty claim. The allocation of forfeitures or the allocation of benefits within a plan, it's arguably a matter of plan design, which would not be a fiduciary function that could give rise to one of these lawsuits. And so that's another issue. And these these weaknesses and others have been pointed out in motions to dismiss filed recently in these cases. And so it'll be interesting to see how courts view them. So our takeaways here is these cases are definitely worth watching closely. This theory about the allocation of forfeitures in a 401k plan, there's no unique allegations about this particular plans that are being targeted. So this is a theory that sweeps very broadly, given that it's a common practice for employers to use forfeitures to reduce employer contributions. So it is really definitely worth keeping a close eye on these cases. And I'd also say for now, besides monitoring the cases, it would be important for a plan sponsor to take a look at how the forfeitures are being treated and make sure that the way they're being handled is consistent with the plan language. So that's certainly a follow-up item that we would recommend. So we're about at the halfway mark of the webinar now, and I want to wrap up the 401k discussion and pass things off to Brian for an update on emerging trends in health and welfare fiduciary litigation.
Thank you, Nate. I appreciate that. So let's switch gears over to health and welfare plan litigation. For some really big picture context here, for the past decade and a half, maybe 2 decades, the organized plaintiffs bar in the ERISA world has been very focused on retirement plans, mostly on 401k plans, but to some extent on defined benefit plans as well. And of course, that's because the plaintiffs' lawyers follow the money. They typically work on a contingent fee basis. So they want big class actions where there's a lot of money involved and play the percentage game. And they've become very good at what they do. In really the last 3, 4, 5 years, and in 2023 in particular, plaintiffs' lawyers have been shifting their gaze towards health and welfare plans. And this is an unsettling prospect for defense lawyers like Nate and me. And because there is a lot of money involved in the US healthcare system, including in employer-sponsored plans that are governed by ERISA. Not only is there a lot of money, the same fiduciary duties apply to the fiduciaries of a welfare plan as a retirement plan. And those duties are governed by a lot of vague and ill-defined concepts like reasonableness and prudence and excessive, words like that where beauty is in the eye of the beholder, and they are a litigator's dream, because how's a fiduciary to know if what they're doing is actually reasonable until a judge has ruled on the topic. So big picture trend that's been creeping up here the past couple years is the organized plaintiffs bar has come for your medical plans. This trend here is what I consider a strategic trend, because the same plaintiffs' law firms that Nate talked about and coming after the retirement plans are now trying to convince employer-sponsored health plans to sue large TPAs. And this would open a battlefront that would have lots of ramifications for all participants, but it's not a one-off thing. We are seeing signs that the plaintiffs bar has made a strategic decision to try to do this, and we know they are soliciting corporate America looking for plaintiffs to sign up, and you don't usually think of big corporations as the plaintiffs in ERISA cases. The theory that's being pitched by the plaintiffs firms to corporate plans is that the plans should be suing TPAs to seek access to claims data, try to get transparency into how TPAs are handling pricing and claims, because certainly one of the attributes of our healthcare system is it's very complex, and there's lots of different players that have different roles, and it's very difficult for any one person to see the big picture. So the plaintiffs' lawyers are telling plans you should sue to get more information. You should argue that the audit rights in your typical administrative services agreement are not sufficient for you to get the data that you need. And then this is the eye-popping contention that is appearing in some of these complaints brought by plans. The plan fiduciaries are contending that they're being stymied from fulfilling their own fiduciary duties to the plan. To me, this is a very strategically risky thing to do for corporate America, because any plan fiduciary who alleges in court that it is, and this is a quote, unable to carry out its own fiduciary duties to the plan, end quote, without more claims data from its TPA, that plan fiduciary is inviting scrutiny by other sets of plaintiffs' lawyers, and inviting scrutiny by the Department of Labor. It just, to me, is a cringeworthy move by a corporate, an employer-sponsored plan to file a lawsuit against its counterparty in a contractual arrangement, saying that our arrangement doesn't give me enough information for me to fulfill my fiduciary duties. To me, that this is it remains to be seen if this trend will get any traction. I'll show you a couple cases that have been filed, and there are others. It all started with labor union plans. Started doing this in 2021. Here's a case against Blue Cross of Massachusetts. The fund alleged that Blue Cross failed to process claims correctly, overpaid benefits, refused to provide data. All things that many plan sponsors are content to have delegated to their TPA if they went through a prudent process of selecting a TPA, if they have a prudent contractual arrangement that allows oversight. Most plan sponsors aren't experts in all these things, and they rely on their TPAs as experts. So it's the plaintiffs' lawyers who are nudging first labor union funds and now employer plans to try to sue TPAs to get more info. That case was followed up in 2022 by a case against Anthem. Again, another union fund is starting to try to look under the hood. And again, the plan is suing its own counterparty, and the counterparty is generally saying, we have contractual arrangements in which we've agreed we'll show you certain kinds of information, and you'll recognize that we have proprietary rights in the way we process claims, and this is a contractual arrangement, and now plaintiffs' lawyers are trying to convince plans to upset that apple cart. The real, to me, interesting case was filed last year by Owens and Minor Inc., a corporation, not a union plan, that sued Anthem and alleged that Anthem, the way Anthem was refusing to provide detailed information about claims processing, it was interfering with their ability to process claims. They actually had a quote in their complaint that said, what you're doing is preventing us from fulfilling our fiduciary duties to the plan, which just as a defense lawyer makes me very nervous to admit in a pleading in federal court. that case was filed, and then it's settled within 6 months, not on a class basis or anything, so the information is not publicly available. So I do not know whether Owens and Minor got what it was looking for, or whether they gave up, or whether something in between happened. So I don't know. One thing we see is there have been a couple other cases like this filed by corporations that are subject to arbitration clauses, or arguably subject to arbitration clauses. So those disputes will be taken even more offline into the more confidential world of arbitration. So it remains to be seen how much we're going to learn, whether this is going to become a large tidal wave, and whether there'll be opinions coming out. And but to me, if these early claims by corporate sponsored plans start to get traction, to me, that's a real sea change. And I just think that for those of us that have been used to seeing 401k fiduciaries sued, and now we need to be thinking about those fiduciary issues as they apply to our corporate health plans. Three other trends that are going on in health plan litigation that are noteworthy. We are seeing participants in health plans challenging the fees paid by health plans. And you have to keep in mind, this is a little bit, this is different than a participant in a 401k plan who has an individual account allocated to them, where they've invested $1,000 and they pick what investments the money is going to be invested in, and then they might complain about investment performance or fees associated with those investments, but they have a particular account that goes up and down, and it's clear to see what their vested interest is in the performance of their particular account. It's a little different when you have a health plan where the participants are paying, presumably if they're paying a share of the premiums, and they have co-pays and deductibles and such, they have some stake in how much the plan spends on things, but it's a little more diffused and harder to pin down. So what you see in these cases, there's an obstacle for participants challenging the fees paid by plans for lack of standing and or the related concept or the absence of a concrete injury. Is this really just a hypothetical complaint by a participant that the plan pays too much for a certain thing? Or does that actually have an economic impact on a particular participant? Kim Wilcoxon, our partner, alerted me this morning that a new lawsuit was filed yesterday by a participant against the Johnson & Johnson's plan, alleging that the plan pays too much for prescription drug benefits. The allegation in this complaint is that the participant identified a particular generic drug that is for the treatment, I think, of multiple sclerosis. And the allegation is that anyone could walk into a drugstore or pharmacy off the street and purchase that generic drug for between $40 and $80 for a 90-day supply. They allege, the participant in this case alleges that the plan, instead of paying $40 to $80 for that drug, the plan has contractually agreed to pay $10,239.69. The complaint says this is not a typo. This is sort of tongue in cheek. And the participant is saying that when my employer has a plan that overpays by some thousands of percent or hundreds of percent, whatever the percentage works out there, that means that I, as the participant, am going to pay higher premiums, higher deductibles, higher co-pays, and I'm going to be paid lower wages. That one seems a bit of a stretch because you're getting farther and farther afield. You can contrast this with, like in the 401k setting, a particular participant's $1,000 investment. You can see how it goes up and down over time and what's been deducted and what hasn't. When it comes to this particular allegation about these generic drugs and the costs, it's just a little harder to wrap your head around how is the participant affected by this. And this is a pretty extreme example. And by the way, it's just an allegation. I have no idea if it's true. But it is an example of a concept I was already going to point out was starting in 2023 about participants bringing ERISA class actions challenging the fees paid by health plans. This could be a whole new front, and 4 years from now, Nate and I could be giving you an update on excessive fee litigation that bakes in health plans like as a matter of course. For now, it looks like it's the beginning of a possible new trend. Another new trend that's really picking up steam are ERISA claims rising out of mental health treatment and parity laws. The takeaway here is that Utah is the new Delaware. Just as Delaware is a preferred forum for corporate law disputes in America and has been for a long time, you're starting to see a lot of mental health treatment and parity claims filed in Utah, where the underlying claim involves treatment for mental health disorders and substance abuse. Because I gather what's happening is that a lot of long-term treatment facilities are being established in Utah, and that and people are traveling from other states to Utah to get long-term treatment, long-term care for mental health issues and substance abuse. It's particularly prevalent that adolescents are traveling to Utah for treatment. Their parents, claim they've tried everything possible with their local doctors, and they try this. Let's send our child to this treatment facility in Utah, which is very expensive, and then try to get coverage from the plan. The disputes that are arising pretty much turn on medical necessity and if there's an exclusion in the contract in the plan for custodial care as opposed to actual treatment, but someone's just going there just so they can be kept safe. So these cases are sometimes there's a few class actions that have been brought against TPAs for the standards that they use to apply to these kind of claims. But really what I'm referring to here are the individual one-off claims brought by participants or beneficiaries who have filed a claim for benefits for what could be a very expensive treatment in a place like Utah. And these stays can be several months to over a year. And so any one claim could be well into the six figures. What you're seeing is a lot of cases are being filed in Utah. You're seeing Utah plaintiffs' lawyers specializing in these cases, and you're now seeing a lot of opinions coming out of the District of Utah, and now that it's appellate court, the 10th Circuit. So this is, I don't think this is going away anytime soon. I think you're going to continue to see more and more litigation over denied claims for mental health treatment, and you're going to see all the arguments about whether plans are treating mental health coverage the same way they treat comparable medical and surgical treatment. This trend is only going to pick up steam, I think. Last trend in health plan litigation that we're seeing is claims against companies' wellness programs for non-compliance with ERISA's non-discrimination provisions. This includes things like plans charging nicotine user fees to nicotine users. There's a whole regime of compliance regime for what the Department of Labor considers a compliant wellness program that is non-discriminatory under ERISA. What we're seeing is both DOL enforcement actions being brought against companies' plans for not paying attention to the details of these specific compliance regimes. You're also seeing private class actions being brought. Again, organized plaintiffs bar, the potential for contingent fee payments. And so I think in the health plan space, we're going to continue to see these wellness claims. The big picture headline on health plan litigation is that it's picking up steam, and it's probably only going to pick up more steam. Okay, we've saved the best for last. Defined benefit plans, actuarial assumptions litigation. Obviously, the most interesting topic. Everybody loves actuarial assumptions. Here, these are claims brought against fiduciaries and plan sponsors of defined benefit plans for the way the plan calculates alternative forms of benefits, that is, alternatives to a single life annuity, such as a joint and survivor annuity or conversions to early or late retirement benefits. There's a whole regime of in ERISA for which there's much fighting about in these cases as to what that regime means and what it says and what's required. But basically, the plaintiffs are saying, if I have a single life annuity and I want to convert it to something else, like a joint and survivor annuity, it's supposed to be done in a way where my joint and survivor annuity is actuarially equivalent to the economic benefit I would have gotten in my single life annuity. That's my, I was a philosophy major, so that's my non-actuarial way of explaining this concept. It's that my single life annuity is not actuarially equivalent to the joint survivor annuity that you're offering me. The two main sources of uncertainty that give rise to room for debate about fascinating issues like this are longevity, that is lifespans of participants, and the time value of money. The lawsuits mostly focus on the longevity piece. That is, when you're creating an annuity, that's a future stream of payments. You need to make some assumptions about the lifespans of the recipients of those streams of payments. So plans use mortality tables prepared by actuaries, many plans were written in the 50s, 60s, 70s, and 80s, and not surprisingly, they bake into their plan terms mortality tables written during those decades. Maybe they've been updated with amendments, but maybe they've just been left in place because if it ain't broke, don't fix it. And the plaintiffs are arguing that life expectancies in America, the opioid crisis notwithstanding, have basically risen over recent decades, and therefore outdated mortality tables are leaving some participants getting less than actuarially equivalent alternative forms of benefits. There have been 29 test cases filed so far. The first 4 were filed in December of 2018, and then the most recent one was filed in December of 2020, or maybe November of 2023. So 5 years, we've had a dribbling of 5 or so test cases a year. This map, when I created it a little less than 5 years ago, had 4 X's on it where the cases were filed. And I was predicting that the plaintiffs over time would try to diversify their portfolio and file in the different U.S. Circuit Courts of Appeal, which are indicated here by different colors. You can see that today, 5 years later, they've got test cases going in every circuit except the Federal Circuit Court of Appeals. The litigation strategy motions to dismiss have not been that successful on a strategic basis. Where the defendants are getting real traction is in defeating class certification. And the reason that class certification is important, because these are lawyer-driven cases where the plaintiff's counsel is motivated by the prospect of contingent fees, and any particular participant's damages are pretty small, but in the aggregate, the plan-wide damages could be very high. So in the Raytheon settlement, which was the first settlement, the plaintiff's lawyer calculated that the average participant suffered a loss of $53.50 a month. So that doesn't sound like a lot of money if you're just being sued by that participant. It's a stream of into the future, of course, so you have to figure out how long that person would live, but the amount in the scheme of things is not that big. But in the same case, in the same plan, plaintiff's lawyer said the plan-wide damages were nearly $150 million. So what sounds like a small individual claim is actually very large in the aggregate. So what the defense world is doing is focusing on the winners and losers problem, which is the plaintiff's lawyers and their actuaries, when they come up with you did this wrong, you used outdated mortality tables, you should have used these other ones. What happens is the defense lawyers sometimes figure out that there are winners and losers within the class. And that is, if the plaintiff is right, some of the class members are going to be worse off. And that the courts say is not that is a grounds for denying class certification. We can't have a class where some of the plaintiffs are going to lose if some of the other ones win. So we've had some cases where the defense world is winning at getting class certification denied and turning these into very small cases. And we've had 4 settlements so far. The first one was the $59 million one, which of course was a couple years ago, and it was very eye-popping because it makes you sit up and take notice that the plaintiffs might be onto something here. But in the ensuing couple of years, the next 3 settlements have all been what I would say is within the cost of defense. $900,000 to $3.5 million. And so it's not nothing, but it does seem like it's neither plaintiffs nor defendants are really winning any strategic end game here. Our takeaways are that the litigation is still inconclusive. I didn't think I'd be saying that 5 years after it was filed. And it's a little too early still to be making changes to your plan because you don't know what you should change to, because we don't have Circuit Court of Appeals opinions telling us who's right and who's wrong, and if the plaintiffs are right, what are the standards that should apply. So, and we have seen a couple of plans amend their terms to use updated mortality tables in anticipation of the plaintiff's arguments, but they still get sued. They just, have cut off their future damages, but they haven't cut off retrospective damages. So it's not a cure-all to go ahead and change your plan terms now, even if you wanted to. So we've been recommending in general that everybody stay in watchful waiting mode. With that, we are at 1:59 Eastern. And Nate, unless you have anything else, I think with that, we will wrap this up and let everyone go. We'll check for questions in the queue, and if you asked a question, we'll try to answer it via email. Look for an email with the slides, which will be sent to you by email automatically, along with a recording of this presentation. And thank you very much for signing in and joining us today.